Stuart Carpy here, and I've got Michael Swanson, and we're doing a Google Hangout. And Michael is the CEO and co-owner of Advocate Capital. He's a published author and educator on law firm financing. And I just wanted to ask Michael some questions today about some articles that I've followed in the news lately about third-party funding of litigation in various parts of the country. My understanding is it's mostly in big commercial cases. I know this isn't quite the kind of stuff that Advocate Capital does, but it's an interesting subject because, I mean, Michael, I told you I read an article about, I think it was in the Wall Street Journal. Here's the headline: Hedge funds $100 million bet Iran will pay for terror attacks. And it's about a hedge fund funding litigation by attorneys in federal court in the United States trying to collect money from the country of Iran for the Beirut attacks many years ago. Fascinating stuff to me. What's your take on all this?
Thanks for asking. I think it is fascinating to think that a case involves an overseas defendant, that a hedge fund can somehow get involved. But I think there's some misconceptions about the third-party litigation funding. And I think it's important to make a distinction, first of all, between commercial and just individual people who are the plaintiffs. I think when it's a commercial suit, which is one company suing a government or some other entity, it's very different because that company is going to, or that sophisticated investor is going to have a much better understanding of the risks involved, of how to go about assessing the risks and how to price it properly. And these are not done as loans; they're done as purchases of future fees. So I really think that there's a place in the market for that. I don't think it needs to be regulated. I think the law firms and the commercial litigants are plenty sophisticated to be able to handle it. I do think, though, if you think about third-party litigation funding for individual plaintiffs, we do see some negatives of that, and mainly it's because you're dealing with an unsophisticated plaintiff who may have been injured in an accident, is cash poor, and we think some of the companies playing in that space are taking advantage of them and charging what I think are effective rates that are usurious, although they don't structure it like a transaction. But look, either way, these companies are responding to a need in the marketplace because the contingent fee law practice model, while it's extremely important to giving our citizens access to the courtroom, it is a very difficult business model to actually play out, especially on those large cases that might last, gosh, 5-10 years and might cost several $1 million to litigate. So I think it's perfectly fine in a commercial sense, and I think that we should leave those firms alone, let them do the work they're doing.
Right, and those commercial entities, they're evaluating the likelihood of success in that kind of litigation, just like the attorneys are who are involved in the underlying case. Right?
Yeah, absolutely.
So they're assessing the risk that way.
Yeah, they're assessing it as a sophisticated investor. They're hiring lawyers, or they're lawyers themselves who go in there and they share in the risk. So their interests are aligned with the law firm and with the plaintiff. Frankly, they want to see a successful outcome, and these transactions are such that these investors are not getting involved in the cases. The law firm is free to prosecute the cases as they wish.
Right. Yeah, it's very interesting stuff. So listen, thanks for joining me on this Google Hangout, and let's do it again on another subject soon.
Yeah, sounds great, Stuart. Thanks for asking about this. This is a very interesting topic. Thank you.